morning, Your Honor.
All right, good morning. The matter is here for a continuance of the ex parte application of the plaintiff to shorten time for a hearing on the discovery motions and deposition of Travis Nurse. I'm granting the shortened time. I'm hearing it today. The court issued a tentative denying both, and the reasons were stated in the tentative. Did you wish to be heard further?
Yes, ma'am. On the motion to compel further responses, I calculated the jurisdiction from the date that this court resumed jurisdiction on 6/17. I added 45 days to that, and the responses were served by mail. The further responses that were served in May, while this court was under federal court jurisdiction. So I do believe that that is timely. That jurisdictional time can expire while the case is not under the jurisdiction of this court. And I didn't see any ruling on sanctions, so there's no jurisdictional deadline on a motion for sanctions.
Well, if I'm denying the motions, there would be no sanctions. You only get sanctions if I would have granted the motion.
The requirement for sanctions, if the motion has not been ruled on based on the merits and only based on the time, then the party is still entitled to sanctions. And
okay. And do you wish to be heard? Or did you want to be heard on the deposition?
The same issue. The deposition of Travis Nurse, I did ask for sanctions, or would like to at least be heard on sanctions in that matter for failure to meet and confer. I did attempt extensively to get the parties to agree on the terms of deposition for Travis Nurse since June of this year, even before this case came back to this jurisdiction, and those efforts were basically ignored and or dismissed. And so I think that whether or not I end up going to Missouri to take that deposition or taking it by video conference or any other way, I spent time and effort preparing that motion because they were not responding to my efforts to meet and confer either before I noticed the deposition or after I noticed the deposition and received their objections.
All right, I'll hear the opposition.
Your Honor, Rick Tozier, Citimortgage. Good morning. Your Honor, we would submit on the tentative with a few additional comments. First, in terms of the timeliness, I would point the court to Ms. Boyd's ex parte, particularly page 4, lines 13 and 14, wherein she said the following. The discovery plaintiff is seeking to compel in the first motion is the production of email conversations which were first demanded in March 2014. That's an admission that she missed the 45-day window provided for by the Civil Code, and thus we think your ruling is straight on based upon the precedent in this state and in that. In regards to the deposition of Travis Nurse, quite honestly, Your Honor, that's why Ms. Granger and I opposed the motion to shorten time. In the ordinary course, I think our position would be that's within the ambit of Your Honor, whether you want to hear a motion quicker or later. However, as you know, I'm relatively new to the case, but as you and your staff know, this case has a fairly tortured history of filings and statements in filings. We wanted to oppose the ex parte to bring to the court's attention both that and to again reaffirm Citimortgage's belief that it is time for this case to come to a well-deserved conclusion. If you recall, Judge, this was supposed to be a settlement conference today. In fact, Kathy Wood-Wagner, who is in Citimortgage's legal department, is here in case Ms. Boyd has any interest in discussing resolution. And that's not, with all due respect, Ms. Boyd, because we fear the substantive allegations. It's quite frankly, Ms. Wood-Wagner is sick of paying us. We'd like this case. This case is over $6,400 of property that Ms. Boyd believes was wrongly disposed of. Of course, we disagree substantively. The reason that we did meet and confer, in fact, as Ms. Granger says in her affidavit, we collectively had over a 30-minute conversation with Ms. Boyd on the deposition. But understand this, as the court knows, it's hard to put somebody up for deposition when there's a motion to compel for their documents. Because as I told Ms. Boyd, our position was, we will put Mr. Nurse up. I will work with you to set up a video conference if you don't want to go to Missouri. Give us dates. But understand, reasonably, I'm only going to put this individual up once. So if you want to take him now, you're running the risk on your motion to compel. We never put people up twice. That's just kind of rote litigation issues. The other thing is, quite honestly, with no disrespect, given the misrepresentations made regarding the conversations we have, Ms. Granger and I both want to be on the phone with her. By way of example, there's a representation in the papers filed today that I told Ms. Boyd, me specifically, that we would not oppose the ex parte motion. Nothing could be further from the truth, Your Honor. What I told Ms. Boyd was I was not meeting and conferring in an effort to get her to take the motion off calendar. I wanted her to know that our good faith attempts to resolve this issue had nothing to do with the pending motion. That's why we coordinate schedules and ensure we're both on the phone at the same time. So if there is a dispute, We can coalesce in terms of our affidavit and declarations to the court. Bottom line is this, the tentative is square on. In addition to the fact that the motion to compel was untimely, as I think Ms. Granger made clear in our papers, this is a second bite at the apple on emails, a duplicative request for production, where Ms. Boyd wrote a letter saying, I only want emails from Mark Alston, the broker at issue, Judge, and these certain city employees. Those were produced. I went back through them myself, and those have all been produced. Now she's come back, notwithstanding the agreement, and says, no, I want the entire ball of wax. I want the entire ambit. That's just not the way ESI works, both from a cost perspective, a burden perspective, and otherwise. And so not only is it untimely, any purported prejudice, which I don't believe she can meet the standard, was really due to the agreement she voluntarily entered into. For that reason, again, the tentative is wholly supported by precedent. But again, the reason Ms. Wood-Wagner here, Judge, is just to demonstrate to the court our good faith in an effort to try to get this resolved if Ms. Boyd is interested. We're happy to step into a room, try to resolve this case if she's willing to be reasonable. If not, we'll continue to proceed with litigation. But with all due respect, I think that's a waste of the court's resources and my client's money along with Ms. Boyd's time.
Did you wish to be heard?
The only thing I would add to what Mr. Cozy has said is to clarify that the production of documents that Citimortgage made was in September of 2014. She's argued this morning that the proceedings in federal court should have somehow told all of that, but her deadline to move to compel expired before this case was removed to federal court.
That's right.
I wanted to make sure that was clear.
Okay, I am going to adopt my tentative in its entirety.
I would like to be heard. The further responses that I last received from Citimortgage in response to that request for production in March of 2014 was received in May of 2015. And as long, the date from which I would be determining that I can file a motion to compel would be from the last set of further responses. It wouldn't be from the date that I served them or their original responses. And I did receive further responses that did include email documents from them in March of 2015.
Okay, I am going to adopt my tentative in its entirety. I'm not going to award sanctions. I think there was substantial justification for not complying under the circumstances. Would you wish to engage in a settlement conference today with counsel?
I'm happy to sit down with them. I'm not sure. I'm always happy to sit down with them, but I do have a couple of questions for clarification.
I'm not going to be answering any more questions on this motion. My question for you is, did you want to discuss settlement with counsel?
Yes, I can discuss it with them. I would prefer to do it this afternoon if that's possible.
No, we would do it this morning.
We would do it this morning?
Right now.
I don't think I'm available to do it this morning.
Why not?
Because when I left the house, my mother is here from out of town and she was sick. And so I can call her and check and see if she's okay to wait for a couple more hours. I can do that. I just wanted to get the date from which you were determining the 45 days for the motion to compel.
Okay, why don't you check to see if you're available?
Okay.
And then come back and let me know, and we can set a trial date if necessary.
Thank you, Your Honor.
Okay.
Thank you. Laurel versus Mortgage, 123-128. Okay, I think that you were unable to reach a resolution.
Yeah.
Or my mother, yeah.
Yeah, she couldn't reach your mother, Your Honor.
I just want to emphasize, I didn't request that the settlement conference be taken off. I am always open to sit down
But
and hear
settlement
if I'm wrong.
conferences are in the morning.
No, I understand that, and I am happy to reschedule it. I am always open to hear what you have
Is
to
your
say,
representative from?
including this afternoon. Yeah.
Okay, well, you can schedule it anytime you want. I mean,
Fantastic.
if you want to just call me on a conference call, I'm happy to schedule something for you. In the meantime, I am going to set this matter for trial.
Your Honor, can I ask one quick, do you only do settlement conferences on Friday, or are they available?
I generally do them on Friday,
Okay.
but if I know I'm not going to be in trial that week, I can accommodate you.
Yes, sir.
So if you see that you want to do it within a couple days, just call me and I'll see if I'm free, I can accommodate you.
Thank you, Your Honor.
It really depends on whether I'm in trial or not.
Thank you.
So, Ms. Boyd, when do you think you'll be ready for trial?
A lot of deposition. I'm going to say July.
I'm not setting it out that far, I'm sorry.
Okay. Well,
I'll give you within 4 months of today's date, so something like February or March.
Your Honor, can I ask one question?
Sure.
My only concern with that is what I understand to be what I call the 105-day rule.
Are you going to make such a motion?
Well, yes, ma'am, we are.
Okay.
That's my
Is it
concern.
ready to go?
No, because quite frankly, Ms. Boyd hadn't taken all the depositions, nor have we.
Well, March is 180 days.
I put together a little chart too. Your Honor, when you say March, you mean if we set it in March?
If I set the trial in March, or actually on my MSJ, if you're going to make an MSJ or an MSA motion, you need to reserve it today.
okay.
Because I'm setting in April.
Okay.
So then I can accommodate Ms. Boyd, and I'll set it in June then.
Okay.
But you need to reserve that motion date today. Don't come in ex parte and say,
Oh, no, Your
by
Honor.
the time we got on, there were no dates, blah, blah, blah.
No, absolutely.
Okay, I'll give you June 27,
Okay.
2016 at 9:30, with a final status conference on June 24, 2016, also at 9:30. I'm gonna have the plaintiff give notice of the defendant give notice of everything.
Will do, Your Honor.
Okay, thank you, and let me know if I can help you with settlement.
Your Honor, thank you so
Thank you.
much.
Okay, thank
Take
you.
care.
All right. I hope your mom is feeling better, Ms.
Thank
Boyd.
you. Actually, yeah, I'm really concerned.